Disability Rights Texas, and we are the federally designated protection and advocacy organization for people with disabilities in Texas. And so we were established in 1977 under the name Advocacy Inc. And we've existed ever since then. Our funding comes from a combination of federal funding as well as state funding through the State Bar of Texas and other private entities. But what we do basically is we represent people with disabilities. We exclusively represent people with disabilities, and we are a legal nonprofit. So our primary goal and our primary sort of mission and reason for existing is one, monitoring the spaces and places where people with disabilities live and exist, and two, providing free legal assistance to people with disabilities whose rights are being threatened or violated. So in our monitoring capacity, we do monitoring of jails, prisons, state-supported living centers, other entities and institutions where people with disabilities reside. And in our legal capacity, what we do is we've got staff attorneys as well as pro bono attorneys that we partner with that practice law in the areas of healthcare, accessibility, voting rights, foster care, institutional rights and civil liberties, housing, transportation, and disaster. We have a variety of different practice areas that we practice in. We also partner with pro bono attorneys, and they take our cases as well. And so with all of our issue teams, along with our pro bono partners, we're able to provide quality legal services for individuals with disabilities all across Texas. We don't have any specific income requirements. We basically, our only requirement is basically that the individual has a disability and it's within our practice areas. We do not practice civil family law, and we do not practice criminal law, and we do not practice personal injury law. So those are three areas that we do get requests for service from time to time, but we do not generally practice in those areas. We continue to provide services to our clients during the pandemic. We do have attorneys that are dedicated to working on issues related to COVID-19 and how they affect individuals with disabilities. With the most recent disaster that happened in Texas 2 weeks ago with regards to the power outages and things like that are still sort of impacting folks in terms of housing and disaster recovery. We have a team that's dedicated to doing that. So if you have anyone in your network or you yourself are interested in getting help or consulting with one of our attorneys, you can go to our website, and there's two ways that you can start an intake with us. The first way is that you can call our phone line, which is this number here. And this line is open from 9 a.m. to 4 p.m. Monday through Friday. We have sign language phone lines, and we also have a few other intake options here that are listed on the website. You can always send an email to us requesting an accommodation if you're having challenges in terms of starting an intake with us. And the quickest way is to do an online service request. Those are processed relatively quickly. Every week we have meetings with all of our staff and all of our attorneys to determine case assignments and kind of how that's going to go. As you can imagine, during the pandemic, we've been super busy with a variety of different issues. No one could have really anticipated how COVID-19 was going to affect everyone, much less individuals with disabilities. And so we've been learning. It's been a learning process over the past year to really figure out where our help is most needed. And so, like I said, these are our practice areas. If anybody's interested in getting help with us, we're always here. Our services are always free of charge, pro bono. And, we're looking to help the most number of people that we can. Also follow us on social media. We're on Facebook, Twitter, Instagram, YouTube. We're also on LinkedIn. Our Facebook page and our Instagram page are fairly active and give pretty accurate updates as far as where we are, what we're doing, what our attorneys are doing, what we're working on. Social media is also a great place to connect with us in terms of what our next clinical opportunity is going to be. So for example, we have an internal clinic, virtual, of course, that's happening on this Friday. So, that'll be advertised on our social media pages. And so if you're interested in participating in any of those clinics, following us on social media is probably the quickest way to find out about when the next clinic is going to be. So that being said, and I also, for everyone that's in attendance, I also put my contact information in the chat box, both my email as well as my my office phone number. So if after this presentation you have questions or you want to schedule a consultation or you just want to talk about any of the information that was presented here today, feel free to give me a call or send me an email. I respond to emails most rapidly because I always have email. I always have this phone on me. So if you want to get a really quick response out of me, shoot me an email. And that's the best way to kind of connect with us. So that being said, I'm going to jump into our presentation.
Hey, Cicely.
Yes, sir.
I'm sorry. I checked the chat box, but I didn't see, unless
Okay.
I'm not doing it right. I didn't see where.
So what happens is, Cecil, you joined in after she put it in. Anytime somebody joins in after a chat has already been in, you won't see that current chat.
Okay.
So I'm going to post it. I'm going to post it one more time, just to make sure everybody has it.
And also, Cecily, I have a survey from Disability Rights of Texas regarding this past winter storm. So
Okay.
if anybody would like to take that survey, it is a real short 5-minute survey, and I can email that to everyone or anyone who's interested in that. Just put it in chat that you want that information.
And our sort of thank you for that, Sheila. Our sort of response and cases and whatnot that are coming in as a result of the winter storm are ongoing. Obviously, we had some fairly robust staffing that happened this week as well as last week, and we're getting daily updates on anything from housing to rental relief to assistance with repairs to accessibility issues. So if anyone needs help in terms of recovery, I think we have some, I don't know if we had, yeah, so we do, we have updated this. So we've got our Texas storm, Texas, it should be Texas winter storm recovery resource. And this is accessibility tools that we have here on our website. So this is this gives you kind of an overview. We do have some calls set up with FEMA coming up to get some more information about what's going to be available going forward. It's very much a moving target. But this is kind of a guide to get you started. And this is the most up-to-date information. I know our communications director is updating this on a daily basis. So if there is someone, either you or someone that you know needs storm resources, assistance with kind of recovering and repairing after the storm, this is an excellent resource on our website. So, and we are accepting cases for representation for people that need assistance. So definitely keep us in mind if anybody's having challenges recovering from Ice-Mageddon 2021. Okay, so that being said, I think, we've got a fairly intimate group here today. So I'm going to be watching the chat while I give the presentation. So if anyone has any questions, just put them in the chat and I'll try to get to them. But I'm going to kind of go through this fairly quickly because I want it to be more of an interactive experience. And I want you guys to have the ability to kind of ask questions about the material as we go along. Okay, so what we're going to talk about first is just kind of comparing and contrasting traditional guardianship with supported decision-making, which is a fairly new development in Texas. I say new, but it's been about 6 years now. So let's start with guardianship. So what does guardianship do? Guardianship requires a court order to establish an ongoing oversight to maintain it. Guardianship completely removes the individual's freedom of choice, self-determination, and independence. It removes all of their decision-making rights, and it assigns those decision-making rights to a third party or the guardian, okay? In Texas, we still use the language guardian and ward, even though that language is fairly outdated. So essentially, the big picture in terms of guardianship is a guardianship basically removes the individual's legal rights and replaces that individual's legal rights with the guardian. Okay, so from a legal standpoint, once someone gets a guardianship over you, you cease to exist from a legal standpoint. Okay, and we'll get into more of kind of what that means practically, but basically, the guardian stands in the place of the individual who is being placed into the guardianship. Okay. So practically speaking, you've got to go to court to make this happen. Okay. And people ask me all the time, well, why do you have to go to court? Well, we are a country that is based on laws and individual freedom above everything else. In the United States, freedom is placed at a premium. And so when you put someone into a guardianship, it is the ultimate restriction of their freedom. You're basically stripping them of their freedom. And so we don't take that process lightly. And that process has to be presided over by a judge, and it is a formal process, and there are no exceptions to that. Even if you want to go in and get an emergency guardianship, if there's an emergency situation, you still have to petition a court, and a judge still has to review that information. And the reason for that is there has to be substantial evidence that it's necessary to go in and remove someone's legal ability to make decisions for themselves and essentially erase them from a legal standpoint and replace them with another person. We take that very seriously. So that's why there has to be a court proceeding that happens. Guardianships are challenging to terminate or modify, especially within the first year. There's an annual accounting and report that has to be done to maintain the guardianship in terms of the condition of the ward. So the court is, once you get a guardianship, the court is going to check in with you every year for an accounting as well as a status update of the ward. And obviously, the reason why this is done is we don't just want to give people guardianship over folks and then just turn them out into the wild and never check back in with them again. Okay. So we want to make sure that people are okay and safe and healthy and everything is going well. What a guardianship does not do is it does not allow for civil commitment. It does not allow anyone to force medication. It doesn't allow for sterilization. It doesn't prevent criminal liability. It doesn't give the guardian power over the person to change their behavior. What it does is it gives the guardian the legal status over this person. Okay, so there's a distinction there. So why families may seek guardianship: the child reaches the age of 18, the school or physician tells them it's necessary, help the child handle money, connect their child with adult services. And up to about 6 years ago, it was the only legal solution in Texas. So important to remember is the law presumes that all adults, including people with disabilities, have the capacity for decision-making. So the court is going to start there when the court is making an evaluation about whether or not to grant a guardianship. And it has to be proven to the court by evidence presented in the case that the individual with the disability does not have the capacity for decision-making. So what happens is if you're seeking to get a guardianship over another individual, you hire an attorney. That attorney then goes about the process of gathering and developing evidence that the individual that they're seeking to get the guardianship over does not have the capacity for decision making. So oftentimes that evidence will come in the form of an affidavit from a physician is the most common piece of evidence used in these cases. But there's also testimony from caregivers, family members, friends, neighbors, relatives, et cetera, that can also be used to bolster the claim that this individual doesn't have the ability to make their own decisions. All of that evidence is presented to the court in a formal court proceeding. Right now in Harris County, those proceedings are being conducted remotely, okay, via Zoom and online and YouTube and things like that. Once we get closer to the end of the pandemic, courts will resume hearing these cases in person. However, because of the pandemic, there's a tremendous backlog of cases. And so it is going to take longer than normal, probably for the next year or two, to actually get a guardianship case litigated in Texas. So once all the parties are involved, the court is going to appoint an investigator, the court is going to appoint an attorney ad litem, and those individuals are going to represent and sort of look after the interests of the individual who they're seeking to place into a guardianship, okay? And so all of these different parties, the attorney that's hired by the would-be guardian, the guardian ad litem, the attorney ad litem, the court investigator, everybody's going to come together in a formal court proceeding and present all of their evidence to the judge. And the judge is ultimately going to make the decision about whether or not a guardianship is appropriate or inappropriate. And judges in Texas have the power to grant a full guardianship, a partial guardianship. So you may, I've seen cases where individuals may petition a court for a full guardianship and the judge hears all the evidence and says, well, I don't think so. I'm going to appoint you as guardian for the limited purpose of helping this individual manage their finances, or helping this individual manage their, or managing the finances for this individual, or managing the, living arrangements or medical treatment for this individual, but I'm not granting you full guardianship. You only have guardianship as it pertains to finances or medical treatment or education or living arrangements or whatever the case may be. And judges have the power to do that as well. So let's see. So I'm gonna kind of skip down. I'm gonna pause right here for a second and see, does anybody have specific questions about guardianship before we kind of move forward?
I do. So
Okay.
what would one do if they were, I'm speaking for an adult child that had been placed under guardianship for the parent to take care of them because they were having seizures or such, or medically not able to take care of themselves. But at this point, then they're ready to resume. How do they go? What would they need? They would have to go to court.
Right. So, and I've actually handled cases like that in the past. So what happens is, what you would do is go in and file either a motion you have to hire an attorney to go in and file either a motion to modify the guardianship, or a motion to terminate the guardianship altogether. Those are the two options. And a motion to modify is going to keep the guardianship in place, but it's going to change certain provisions of it, right? A motion to terminate is going to terminate the guardianship altogether. So the example that I like to give is, years ago, I represented a client who was involved in a very violent assault in San Antonio. And he was the victim of this assault, and he ended up being in a medically induced coma for 6 months after this assault. So obviously, being in a coma, he was not able to participate in any of the decision-making that needed to be made in terms of his medical care, recovery, therapy, surgeries, et cetera. So his sister petitioned the court and became his guardian. 9 months later, he came out of the coma. He started on his road to rehabilitation, and probably about 6 or 7 months after that, he was healed and rehabilitated to the point that he could at that time resume decision-making over his own sort of life and affairs. And so at that point, we went back to court and filed a motion to terminate the guardianship. and produced for the court evidence that he no longer required the guardianship oversight of his sister because he had come out of the coma. He had gone through over a year of rehabilitation and therapy. He was able to walk again. He was able to talk again. His sort of cognitive limitations were not such that he needed to remain in the guardianship. So the same process that you're going to go through to get a guardianship established and get a court order establishing the guardianship, you're going to have to go through the same process to terminate it or modify it. Okay. So that, and that's because it's a formal court proceeding, and the only way to unravel a guardianship is to go back to the same court that you went to get the guardianship. Okay, let's see. I think Cindy has a question.
Yes. What type of an attorney do you consult with?
So in order to get a guardianship in place or to terminate or modify an existing guardianship, I would recommend getting a board certified probate lawyer. Okay. They're the ones that basically in Texas have the expertise to kind of handle those cases. We do not, Disability Rights Texas does not do guardianships. We do alternatives to guardianship and supported decision-making, and we terminate or modify existing guardianships. But we do not practice in the area of helping people obtain guardianships, mostly because there's a fairly robust private practice bar in Texas that sort of manages and covers those cases. And in terms of our organizational priorities, we tend to err on the side of self-determination. And so because of that, we just philosophically don't do guardianships. But there are lots of private attorneys all across Texas that do guardianships, and many of the other legal aid organizations do guardianships. If anybody's interested in a referral to some of those organizations, shoot me an email and I can get you that information. But you really need to consult with a probate attorney. I recommend a board certified probate attorney because guardianship is a complicated procedure, and the attorney really needs to know what they're doing. There are motions that have to be filed. There are affidavits that have to be filed. There's going to be an investigation that's done by the court investigator. They're going to run a background check. There are documents that have to be submitted in terms of a financial inventory to the court. So the lawyer needs to know all of that stuff. And somebody that is not board certified in probate law may not necessarily know the ins and outs of that. So it's very important that they know what they're doing and they have some experience.
I have one more question. What age
Sure.
population do you find that people are requesting this?
So it varies. And truthfully, since Texas has adopted alternatives to guardianship, we've actually seen them go down fairly dramatically. But I would say the number one population that we see being placed into guardianships are elderly individuals. Okay. So individuals that are over the age of 80 that suffer with dementia or Alzheimer's or other cognitive impairments, those are the most common. Probably coming in second are individuals kind of like my client that I was telling you about that have a temporary loss of capacity due to injury, whatever the case may be. That's probably the next common. The third most common is our transition age youth, right? So individuals that are 17 years old, getting ready to turn 18, and they're individuals with disabilities and their parents are seeking guardianship over them. So those are the three big categories of folks that we see getting into guardianships in Texas.
Thank you.
I have a question.
Sure.
So what happens when your guardian is deceased or has just passed away?
Right. So once the guardian is deceased, it's back to square one.
Okay.
Because once the guardian is deceased, the guardianship automatically terminates by law. So what happens is the state of Texas takes over and steps into the place of where the guardian would be. And the process starts all over again in terms of providing the individual with the disability with the supports and services that they need to live in the community. Unfortunately, in Texas, a lot of times if there is not another family member that is willing to step in and be the guardian, or if there's not an alternative arrangement that can be made, sadly, some of those individuals do end up being institutionalized in Texas. Okay, so, but yeah, that's generally what happens is once the guardian dies, the guardianship terminates, the court takes over, and the search begins for someone else to come in and take the mantle and do that process all over again.
Okay.
Does anybody else have any questions? Let's see.
Yeah, I just had a quick question. How does guardianship differ from power of attorney? Because it sounds like a lot of those things can be handled under power of attorney too.
Right. So the difference, and we're going to get into that a little bit later in the presentation, but the difference between guardianship and power of attorney is that the guardian literally steps in and becomes the decision maker for the individual with the disability that's placed into a guardianship, and they lose their legal capacity to make that decision. A power of attorney, when paired with other supports and services, adds another individual to the mix, to the decision-making mix in terms of making decisions for the individual with the disability. So the difference between getting a power of attorney along with a supported decision-making agreement, for example, that would add mom or dad or aunt, uncle, or grandma or grandpa into the mix and give them the ability to participate in making decisions for the individual with the disability, but it would not remove the individual with the disability's capacity to make their own decision as well. So basically you're adding people to when you use power of attorney along with alternatives to guardianship like supported decision-making. You're not erasing the person's legal capacity. By contrast, what a guardianship does is it erases an individual's legal capacity. So they literally cease to exist from a legal standpoint. So they can't make any decisions at all. And all of those decisions reside with the guardian. So a guardianship is a little bit more, I would say, drastic than a power of attorney. And plus guardianship, if you get a full guardianship granted by a court, you, as that individual's guardian, have the ability to make all of their decisions for them, right? So it doesn't matter what the decision is. It could be housing, it could be education, it could be medical care, it could be support services, resources, benefits, medications, whatever the case may be, whatever it is, the guardian is making that decision. With a power of attorney, it's limited, right? So with a power of attorney, you may have a durable power of attorney that gives certain types of decisions over to the individual that holds the power of attorney, mainly financial, right? With a durable power of attorney. You may have a medical power of attorney that gives the agent, which is what they're called under the power of attorney, an ability to make medical decisions, but nothing else, right? So a power of attorney is a little bit more targeted. It's a little bit less overarching and far-reaching, and the person retains, the individual with the disability maintains their self-determination over the rest of the decisions that are in the bucket, right? With guardianship, that doesn't happen. There's no retention of any decision-making capacity with a guardianship, with a full guardianship. With a full power of attorney, it's just carving out the little piece, and that's it. Does that make sense?
I have a
Yes.
question.
You have another
It
question?
does. Thank you.
Sure.
If a person has power of attorney over you and you are recovered, is there anything differently that you need to do to try to remove that? Or is
Right.
it just,
So if someone has power of attorney over you on a temporary basis, and you've now, and it's not, you know, necessary to have anymore, then that power of attorney just simply needs to be revoked. And there are rules set up within the power of attorney. You can actually have a power of attorney that terminates on a specific date, right? So within the confines of that power of attorney, you can kind of dictate how long it's going to last, who it's going to be, if there are any alternative agents, things like that. So you can set it up when you draft it to terminate on a specific day or time or whatever the case may be. And you don't have to go to a court to petition a court to have that power of attorney terminate. It can simply be revoked by the individual who granted it in the first place.
What if the individual didn't really have a choice? And I'm speaking from my own, I was incubated during that time. So of course, someone needed to make decision for me. But once I gained my conscience and was able to make my own decisions, is there something else that I need to do?
No,
Once-
you just revoke the power of attorney. I mean,
That's-
the thing about a power of attorney is that you're always presumed to have capacity, sufficient legal capacity to enter into a power of attorney in the first place, right? So when you grant someone the power of attorney, you have the ability to revoke that power of attorney the same way you granted it, because the law never presumes that you don't have the capacity. The law simply presumes that you're giving someone else the ability to make decisions for you within this limited circumstance. So the same way you gave it, you revoke it, you take it back. So if you wanted to terminate, it terminates. You basically say, I revoke my power of attorney, and there's a document that you can execute and have notarized and revoke it, and let everyone know, all the interested parties, that are involved, that you revoke it, and that's the end. You do not have to go to court to revoke a power of attorney because your legal capacity has never been challenged. A power of attorney is something that you give. It's not something that a judge grants another person because you don't have the capacity. A power of attorney is something that you willingly give over to another person. So the same way you willingly gave it over, you willingly take it back. Okay. So there's no real legal process that exists for someone to revoke a power of attorney. It's literally just letting everyone know, I revoke my power of attorney, filling out the document, letting the agent know, the individual that was appointed in the first place, hey, I'm revoking my power of attorney, I'm taking it back from you. And that's pretty much it. That's the legal process.
So the person that was granted the guardianship is the one who can apply for the power of attorney over this person?
No, you don't need guardianship and power of attorney.
Okay.
That's basically a legal redundancy. Okay.
Okay.
A guardianship is basically, it stands on its own. Okay. So if you have a guardianship over a person, then you have a full guardianship over another individual. You control everything in their life.
Okay.
Okay. If a judge grants you a full guardianship, they no longer exist from a legal standpoint. You stand in their place. Okay. That's why they're called a ward. Okay. So you don't need to go in after that and get a power of attorney. You are the agent. You are basically them. So if I get a guardianship over you, Cindy, you cease to exist legally. And now me, Cicely, I am now making all of Cindy's decisions as if I am Cindy.
Okay.
So I don't need to go get a power of attorney. I already have it. I have ultimate power over you completely. So that means I decide everything from where your money goes to where you live to whether or not you're institutionalized, whether you drive, whether you work, whether you get married, all of that decision-making resides within me. Until such time that a judge revokes that power and takes it away from me. Okay. And there's only certain limited cases where a judge is ever going to do that. So if it's a case of abuse or exploitation or breach of fiduciary duty, then, you can file a petition, or someone can come in and file a petition on your behalf and say, hey, Cicely is Cindy's guardian, but, she's abusing her and this needs to stop. So they'll have a hearing and the judge will hear evidence and determine if the guardianship should continue or be terminated on that basis. But absent that, once you get a full guardianship over someone, it requires a court order to modify it or overturn it. And it's only modified or overturned if there's evidence presented to support the modification or to support it being overturned. Because remember, the purpose for the court granting a guardianship in the first place is protection, right? This is an individual that doesn't have the legal capacity to make their own decisions. And so we're going to allow this other person to make their decisions for them, to keep them safe and protected, and to give them access to the supports and services, medical care, whatever the case may be, that they need.
So they're not of sound mind, is what you're saying.
Right. This is
Okay.
a person who is either not of sound mind or an individual who lacks the capacity to make those decisions. So like I have clients that are completely nonverbal and completely not mobile. So they lack the physical capacity to make their own decisions because they're nonverbal and they're non-mobile, and they have the intellectual capacity. They may be 35 years old, but they have the intellectual capacity of a 5-year-old, right? That is an individual where guardianship would be appropriate for them in order to keep them safe and give them access to the things that they need, because they literally lack the physical, mental, psychological capacity to make those decisions for themselves, okay? So under those circumstances, a court giving that individual a guardianship is appropriate to keep them safe and to help them live in the community, you know, with their family or whatever the case may be. By contrast, I've also had clients that have Down syndrome, who are high functioning, who have jobs, who go to school, who work. And I've had, you know, people try to get guardianships over them. Well, that's an individual that has the capacity to make their own decisions and is actually functioning just fine in the world without a guardian. And so that would be someone who's inappropriate for guardianship, and for someone to come in and try to get a guardianship over that individual over their objection is something that would be inappropriate and that a judge probably would not grant in Texas, okay? So you, and every case for guardianship is different because every individual with a disability is different. A disability, you know, the label of disability is a somewhat dubious label because you have individuals with disabilities that are very high functioning and that don't need to be in a guardianship, and that are perfectly capable of making their own decisions about where they want to live, what they want to eat, what medical care they want, you know, what training they want, you know, how they want to live their lives. And we ultimately believe as an organization that everybody has that right, regardless of your ability, disability, whatever the case may be. And so, you know, in Texas, the law has changed, and I'm getting ready to kind of get into that now. And the culture has changed surrounding that issue. And when we talk about the ability to make decisions, let's be clear, we're not talking about the ability to make decisions based on the quality of those decisions. And that's a misnomer, you know, that we hear a lot is, well, you know, if I don't get a guardianship over my teenager, you know, then they're going to be running around with people they don't like. Well, if your teenager did not have Down syndrome, they would still be running around with people that you don't like, because that's what teenagers do, okay? That's par for the course with teenagers. They're going to run around with people that you don't like. They're going to make bad decisions. There's nothing about being a person with a disability that should exempt them from making bad decisions. People make bad decisions whether they have disabilities or not. You know, some would argue that my life has been nothing but a string of bad decisions. So, you know, we're not going to judge people's ability to make decisions based on the quality of what we think those decisions would be. And that's not a standard that a court is going to look at in granting a guardianship. Courts are looking at capacity. What is this person's capacity? Do they have the mental, emotional, and physical ability to participate in their own decision-making process? If the answer to that question is yes, then a guardianship isn't appropriate. That's the legal standard. So, you know, you cannot go into a court anymore and argue that I need to be a guardian over this person, because if they're their own guardian, they're going to make decisions that I don't agree with, or that I don't like, or that I think are bad or detrimental, or whatever the case may be. It has to be that the individual lacks the capacity to participate in their own decision-making process, and a guardianship is necessary for their protection. Does everybody kind of understand that distinction? Okay, perfect. Does anybody have any other questions? Looking at the chat. No? Okay. All right, let's kind of skip forward. I'm running a little bit long, so I'm going to go down to, let's talk about alternatives to guardianship. We've kind of covered guardianship. So what is the law in Texas surrounding alternatives to guardianship? So there have been significant changes. For the first time, the Texas legislature mandated that probate courts consider alternatives to guardianship and supports and services before a guardianship is created. So this is kind of a big deal, okay? It's never happened before in Texas. So what that means is, even if you file a petition for guardianship, when the judge is reviewing that petition for guardianship, in the back of that judge's mind, he's going to be thinking, okay, is there a less restrictive alternative to this guardianship to accomplish the same goal? Okay, which is the protection and the well-being of the individual. The judge is going to be thinking that throughout the entire hearing. Even if the judge doesn't voice it, that's what the law mandates. Okay, so guardianship reform in Texas happened in 2015. 84th legislature adopted supported decision-making and alternatives to guardianship, and all of these provisions can be found in the Estates Code. If anybody's interested in doing the extremely interesting and fascinating reading of all of the lawmaking history of this process, feel free, have at it. It's on the internet, super boring, great. If you have insomnia, just pick it up and read it one night. Alternatives to guardianship that are listed in the Estates Code are medical power of attorney, durable power of attorney, declaration for mental health treatment, representative payee, and joint bank account. So supports and services are defined, and it's basically how can we use the tools in our disposal and in our toolkit and in our toolbox to meet this individual's needs without having to place them into a guardianship. That's essentially what supports and services mean when we think about that. So how can we meet their needs for food, clothing, shelter, physical, mental health, financial affairs, residence, housing, voting, operating a motor vehicle, marriage, employment, etc. How can we meet this person's needs in the community? So common supports and services, mostly trusted individuals, family members, and friends, community-based Medicaid waiver programs. I'm not going to get into how I feel about the Texas Medicare Medicaid program. We'll save that for another day. Case management services, person-centered planning, free or reduced price meals, foods, prescription delivery, assistive technology. All of these things kind of come into play when we start thinking about supports and services. So a supported decision-making agreement is the specific alternative identified in Texas law as a specific alternative to guardianship. So Texas is the first state to authorize supported decision-making as a substitute for guardianship. This was done because the probate courts in Texas were being overwhelmed with guardianship cases and clogging up and backing up the probate courts. And so these changes and this adoption of alternatives to guardianship was done to free up the courts. So what is supported decision-making? It's defined by the statute as a process of supporting and accommodating an adult with a disability to enable the adult to make life decisions, including decisions related to where the adult wants to live, services and supports and medical care the adult wants to receive, whom the adult wants to live with, and where the adult wants to work without impeding the self-determination of that adult. Who can enter into a supported decision-making agreement? Any individual over the age of 18 who has the physical or mental, who has a physical or mental impairment that substantially limits one or more of their major life activities. That's the definition of disability taken right out of the ADA. And the level of capacity the person must have in order to enter the agreement is not defined. However, the person must understand the nature and consequences of his or her entering into a supported decision-making agreement when the supported decision-making agreement is signed. So this is kind of where the lawyers come in, right? In determining whether or not an individual has a capacity to enter into a supported decision-making agreement. I always say that, you know, the clients don't need to understand the ins and outs of Texas law in order to be able to enter into a supported decision-making agreement. What they need to be able to do is have the mental, emotional, cognitive, and psychological capacity to participate in their own decision-making process with the assistance of a trusted person there to kind of help them, okay? So, and that's, you know, that's one of those things, you know, in law practice when it's, you know, when you ask me what the definition of capacity is, my response to that is, I know it when I see it, and I know it when I don't see it, okay? So the only way to really determine that is to have a consultation with an attorney, to have a conversation with the individual with the disability, to have a conversation with the potential supporters, and determine if a supported decision-making agreement is appropriate. And over the years, I have had clients come to me that are interested in a supported decision-making agreement, but after interviewing them, I determined that legally they lack the capacity for it and that a guardianship is a more appropriate alternative for them. Every case is different, every individual is different, every set of circumstances is different. But it has to be evaluated and looked at from the standpoint of, is the capacity there? And if the capacity is there and we can provide the supports and services, then a guardianship isn't appropriate, okay? Who can be the supporter? Any adult. The law doesn't place any restrictions on who can become a supporter. It needs to be somebody that they trust. It's usually a family member. 90% of the cases it's parents or sibling. The individual does need to be in Texas. I've had a few cases lately where they've been trying to get a supporter in another state. The supporter does need to live in Texas and preferably live in relative close proximity to the individual that they're going to be supporting. Reason being is because we cannot use an out-of-state supporter because the person has to be able to submit to the jurisdiction of the courts in the state of Texas in case anything goes wrong, okay? Let's see, so there's a question in the chat. Yes, please share. Okay, so is it voluntary court ordered? It's voluntary. So supported decision-making agreement does not require a visit to court. It doesn't require an attorney. It doesn't require any of that. It's an informal voluntary process where you simply execute the documents and get them notarized. It's just like a power of attorney. How is it different? It's distinct from a power of attorney because it does not allow the person to make decisions for a person. The person with a disability retains their right to make the decisions. They simply are utilizing the supporter as a tool to assist them in the decision-making process. What can a supporter do? They can basically assist and support, right? So they can assist the adult with a disability in understanding options, assessing and collecting records, understanding information, processing information, communicating their decision to the appropriate people. They're basically there as, an arm of support for this person, but they're not substituting their judgment in place of the judgment of the individual with a disability, right? So they're sort of like a life coach in that way, right? What about confidential information? There's a release that can be executed to give the supporter access to confidential information if that's something that's desired. It does not prevent a person with a disability from seeking personal information on his or her own without the assistance of the supporter. It simply gives the supporter, in some cases, access to information that would otherwise be confidential, and it does not violate HIPAA in that way. Fiduciary duty, yes. At first, when this alternatives to guardianship legislation was passed, there was a question mark about whether or not a fiduciary duty existed. That question has been cleared up. And in Texas, a supporter has a fiduciary duty the same way an individual who's the guardian has a fiduciary duty. And so what that means is you have a duty to act in good faith and with loyalty, avoid conflicts of interest, abuse, and exploitation. And if anyone suspects abuse or exploitation, the reporting process is the same to the Department of Aging and Family Services. So either way, if it's a guardianship or if it's supported decision-making, if there's abuse or exploitation going on, Texas law steps in and kicks in to protect the people with disabilities from any abuse or exploitation. Does the supporter have a fiduciary duty? Yes. When does it end? When it's terminated by the adult with the disability, or it can be terminated within the context of the agreement. You can put an end date. So I've had clients that have decided to forego a guardianship and try supported decision-making for a year to see how it works. And if it works well, then they come back and do another one for, 10 years, 20 years, whatever the case may be. But it can be terminated at any time, okay? And, you can try out a supported decision-making agreement for a year or 6 months or whatever the case may be. And if it doesn't work, then you can always go to a court and petition for guardianship. But the reverse of that is not true. If you get a guardianship and that's not working, you've got to go back to court and terminate it before any other options can sort of be considered, okay? What are the requirements? The adult with a disability and the supporter have to sign the agreement and it's got to be notarized. There's a sample agreement in the estates code. There's also sample agreement on our website. We've got, let's see, resources. There it is. So this is all of our supported decision-making resources on our website. And here's the sample agreement right here. So it's fairly easy to fill out. You simply put your name, put the name of the supporter, check the life decisions that you're interested in getting assistance with. The agreement starts when signed and will continue until you can put an end date. Then you sign and date it, and then the supporters sign the second page, and the notary does their thing here. And so this is kind of a warning with certain information, but that's, in a nutshell, this is the agreement. So we've got these downloadable forms on our website. And we also have our right to make choices guide. And this is kind of the end all be all of all of the supported decision-making information that we have. We put this together in partnership with several other organizations. This has been around for probably about 5 years. I don't leave home without it. I always have one of these on me. And let's see, we actually have there's a physical book that this is, but this is the PDF kind of downloadable version. But this also has a lot of great information about supported decision-making. We've got videos, we've got all kinds of information here. So if you want to know more about all of this stuff, you can always get on our website and kind of look at all of that. Reliance upon a supported decision-making agreement. I have not had a case in about 2 years where the reliance on it has been questioned. I have, had to make some phone calls and kind of talk to some folks and get people up to speed, just individuals that had never heard of it before. But we, to date, in the last 6 years, have not had any of them contested in court. So that's a good thing so far. Abuse or exploitation, as we covered, same requirements, you just report it to DFPS. Is it binding on a third party? I think the answer to this is yes. Can it be used along with other alternatives to guardianship? Yes, we typically draft these with powers of attorney, and they're all kind of used in concert together. And that's the end. I ran through that last part kind of fast. I think there's a question. Are there any other questions about that?
Yeah, well, this is a general question. Are any of these rights, I mean, I'm sure some of them do they go across all states? Or do we have or some of these rights, are they focused on individual states at certain levels?
That's a really good question. The answer is no. It depends on which state you're in. All of the laws in all of the states are different. So you have states like California, Texas, Massachusetts, Maine, Illinois, a handful of other states. Georgia, I think, is one that have all adopted supported decision-making in some capacity. And then you have other states that have not. And so the supported decision-making law really applies in Texas as we reviewed it today. If you move to California, they also have a supported decision-making law that mirrors ours and is very similar to ours. Same with Illinois, same with Massachusetts, same with Maine. If you move to Idaho, I don't know. I'm actually only licensed to practice law in Texas and Louisiana. So I'm not really super adept on a lot of what's going on in the other states. I know there are a bunch of other states that have passed supported decision-making, but if you enter into a supported decision-making agreement in Texas, Texas law governs as long as you're in Texas. When you leave Texas, you got to start all over again.
Okay.
Yeah. Any other questions?
Well, just to piggyback off of his question, does that include, like, if you're just traveling, like not moving permanently out of the state?
Yeah, if you're just traveling, it's fine.
Okay.
And I would, when you're traveling, take the documents with you. Make sure you have a copy of the powers of attorney, supported decision-making, release of information, anything that may come up if an emergency comes up. But if you're just traveling, no, you wouldn't need to worry about it.
Okay. And then my other question I was going to ask, do you have to have the forms filled out? Because I never heard of the supported decision making. That's kind of how me and Pat's daughter kind of work with Pat, is that we kind of help her make the decision. We have never.
Yeah, I would recommend formalizing it. If you're already in, and this is the case with a lot of our clients, is they're already sort of in an informal supported decision-making sort of process. So if you're already there and you're already doing what's described by the law, just formalize it. You know, do the documents, do the power of attorney, do the supported decision-making agreement, do the release of information, so that if anything comes along, because usually when these documents become necessary is when some event has been triggered, and you've got you're sitting across the table from someone that's demanding, you know, documentation of whatever. So just have your ducks in a row and have everything kind of set up, you know, the way you need it prior to any emergency arising. I would say if you're already doing this, just memorialize it. Absolutely.
All right, thank you.
And it's very simple. Like I said, the documents are on our website. Our offices are still closed to the public due to the pandemic, but we are doing Zoom consultations with clients where we go through the whole process of how to execute all the documents and getting all that done in a normal cycle. And the normal sort of way of doing things is, prior to the pandemic, I had clients come into the office and meet with me in person, and we would sit in the conference room and have all the documents spread out, and I would kind of review each document. And I have my assistant, who's also a notary, would come in and everybody sign and execute the documents. We keep a copy of the documents in the form of an electronic file. Everybody goes on their way, everybody's happy. Obviously, since the pandemic, our offices have been closed to the public, so we don't have clients coming in to execute these documents the way we did prior to the pandemic. But we do still do the consultations, and we do still walk people through the process of how to execute the documents. So if that's something that you're interested in, and you're in the Houston area, you can just shoot me an email or give me a call, and we can definitely assist with that.
Okay, thank you.
Any other questions? And obviously, if after this presentation you're thinking about something and you're like, oh, I should have asked this, I'm going to put for anybody that came in late, I'm going to put my email and phone number in the chat box. And you can always give me a call, or you can always email me. Emailing me is the best way to get a hold of me. Let's see, 681-82. Oh yeah, so emailing is always the fastest way to get in touch with me. I would not recommend calling, because while I am in the office here today, I'm not here every day because of our social distancing rules and kind of how that's going. Most of the time in the pandemic, I've been working from home. So the quickest way to get a hold of me is to email me. Let's see, that did not go through. Let's see, everyone. Let's try this again. There we go. All right. Does anybody else have any questions? If not, I'm going to hand it off to Jeanie. Jeanie,
I have something, but I will talk to you about it later. It's about one of our members that I need to get information on.
Okay, perfect.
I'll email you later about that.
Perfect. No worries. Jeanie, I'm sorry. I went over time a little bit.
That's all right. I think supported decision-making is so interesting. And I used to be before I started working at Disability Rights, I used to be a certified guardian, and I've never implemented it, but which I'm glad for, because of our philosophy. And but I did have to take a test, and it is a lot of
technical.
It's very
hard.
technical.
It's hard. I mean, we go to those CLEs every year where they teach us about, guardianship and the process and all that. And it's not easy. It's hard.
Mm-hmm.
And it's interesting because I don't know if you guys, I know during the pandemic, I've been doing a bunch of Netflix, everything, Netflix, Amazon, Hulu, HBO Max, literally just all of it. And so there's a new movie on Netflix called I Care. I don't know if you've seen this movie or not. But anyway, it's a nightmare scenario.
It was horrible.
Of a guardianship gone extremely wrong. And so the first thing that happened, on social media, I was kind of manning our Facebook page a couple days after that came out, and people were asking, is that real? Does that really happen? And the answer is yes, it does really happen. Now, the movie is a little far-fetched and Hollywoodized to make it interesting. But essentially, the plot of the movie is this individual is a professional guardian for profit, and they target wealthy elderly individuals and attempt to sort of try to take over, their affairs and take over their estate. And so the movie sort of depicts this kind of nightmare scenario where you have this perfectly independent elderly woman who's living a pretty fabulous life. She's got a fabulous house, fabulous car, lots of money, and she's totally independent. She does not need a guardianship. And so this private guardian kind of swoops in and in a very unsavory way creates this evidence, and the plot kind of goes from there. But it is a good example of the process of guardianship, and that part of the movie is actually not hyperbole. That is how the process of getting a guardianship goes in a court with attorneys when the evidence is presented. So I will say that it's been very interesting because it's opened a lot of people's eyes about the process of guardianship and kind of how all that goes. But yeah, I mean, it's very complicated and it's expensive. Probate attorneys charge a lot of money for guardianships. I've heard as low as $2,500. I've heard as high as $10,000. Now who charges $10,000 for guardianship and gets away with it? I don't know. But I've seen, legal fees that are fairly exorbitant, depending on the complexity of the case. So
What was the name of the film again?
it's called I Care.
Oh, okay.
And it's on Netflix. It's streaming on Netflix right now.
Thank you, Cicely. That was interesting. So
I think it was called I Care a Lot.
Yeah, maybe called I Care a Lot. I think you're right. Yeah.
My name is Jeanie Hanzal. I'm an advocate with a client assistance program at Disability Rights Texas. And I'm not an attorney, but I'm supervised by an attorney. And we're going to switch over from talking about supported decision making to looking at work or living independently. Because that is my program is very specific to individuals who are seeking employment or services through the Vocational Rehabilitation Program in Texas, or who want to do that, or individuals who are receiving services or want to receive services from a Center for Independent Living in their community. An advocate's role is, of course, very different from working as an attorney. Of course, I'm not licensed to practice law by any means. I've been an advocate with disability rights for 3 years. And prior to that, I was a rehabilitation counselor. And I've done private work and some state work also. And I'm a certified rehab counselor. And I also am a certified forensic rehabilitation counselor, which means I spent some extra time in training for a year looking at research. And the forensics is really the process is conducting research and evaluation and kind of digging in a little bit deeper into a process of things. A lot of you are already advocates. You're maybe a self-advocate, or you are an advocate for another individual. And an advocate's role is to establish and expand and protect and enforce the rights of individuals and provide information about those rights. And we assist individuals with disabilities to learn how to maybe feel more comfortable doing so, and speak for themselves regarding their personal employment goals and how that, and their desires and how that looks for them individually. The client assistance program is, it originated as a pilot project in 1973. And in our vocational rehabilitation program, where they're state and federally funded. And it was mandated in 1984 that if the vocational rehabilitation program wanted to draw down federal funding from the Department of Education now, they would have to have a cap in their state. So of course, every state wants to have the federal funding match. So we have, every state has a client assistance program. And we are mandated. Are any of you familiar with vocational rehabilitation services, or have you received information?
I actually have been in the process now of going through the Texas Workforce Ticket to Work program. But because of
Wonderful.
the pandemic, you know, I'm at work now. So we're just waiting for that. But because of connectability, I was able to get some serious help towards that. I've gotten counseling, therapy sessions, even went to see a psychiatrist. So right now it's on hold. We'll see what happens.
Well, I'm glad that you've connected with them. In fact, you know, the vocational rehabilitation program is when you have the right mix of people, you know, the right team, it can be a very positive experience.
Yeah, exactly.
Yes, and we see people sometimes when their experiences aren't so positive because the state is required to inform individuals about the client assistance program at application, during the plan meeting, at closure, and any time that there is a disagreement about services or a plan goal. And our role is to really help facilitate collaboration and communication. We try to resolve issues at the lowest possible level, meaning that we do a lot of the groundwork, we research, try to bring the parties together, and all the while keeping my attorney supervisor apprised of, you know, things that might come up or any bumps in the road. And she ultimately decides, you know, if there is a denial, if she would, you know, represent an individual at appeal, and or if we would, what kind of guidance that we would give them. But oftentimes when I'm providing training and information to the counselors with the VR program, I remind them that there's more that they can do than what they cannot do. So we want to ensure that they're notifying their customers of what they're able to do rather than looking at their policy of, well, we can't do this or we can't do that. Because as you mentioned, you know, you have access to a wide array of services to help you as a whole individual in order to prepare you for work or to sustain your employment if you are working. And services range from evaluations and tests to medical services, counseling and guidance, training, assistive technology. For individuals, they have staff that are available who work for the state, or they hire vendors to provide more comprehensive evaluations depending on the individual need. If someone needs an interpreter, they provide that, or orientation and mobility training for individuals who are blind or visually impaired and might need some extra training to get around their community independently. One of my favorite services is supported employment, because it's a little bit more comprehensive for individuals to get out into the workforce. And they also offer supported self-employment too, where there are, it's a comprehensive program where there is an individual who's familiar with talking about disability and accommodations. And it's kind of an extra arm of the counselor, but they're there really for the individual who has a disability, maybe to convey any accommodation needs that they might have, or whether it's a work schedule, or to help with training also on the job.
Can I revert back a little bit to the training?
Yes.
Being that I'm new to disability also, I haven't worked in a long time. So how are you able to reacclimate the individual, trying to get them back to work?
Do you
Is there
mean,
like a training program, something?
well,
Like, or do you assess the needs of the particular position? Like, how does that work overall?
that's a very good question. Thank you for asking that. And it's very individualized. So it depends on what are your goals, what are your needs, your desires, your interests, and your, and your potential. So training can be, advanced training could be anywhere from certification to a PhD. And the idea is that, and the law changed in 2016 really significantly. Well, and it was clarified more, it was clarified, to be honest, because I think for a long time, vocational services was looking at, well, what can we do to help a person get a job? Well, we need to look at what does the individual want to do and what are they capable of doing? It's not providing the minimal services. And so if an individual wanted, so for example, I'm working with a medical doctor and he's not able to do vascular surgery anymore. And his counselor and I had a discussion about, the counselor was having a hard time getting over the idea that this person had a medical doctorate. And he thought, well, how can this person need any more services if they've got all this training? Well, there's a lot of things that really went into that because it's very specialized training. The disability prevented the individual from practicing medicine, and his interests were changing also. So it took a little, sometimes we're counseling the counselor to wrap their heads around working with individuals who have disabilities and what that might look like. And that's okay, because we're here to help with a collaborative process. So we were able to kind of get beyond that. And it was very satisfying, I think, for both the counselor and the customer. So to answer your question about training, it really depends. What is it you want to do? Do you, and who offers the training? How do you get there? How do you achieve that training if it's needed? Or do you want on-the-job training? On-the-job training is a different approach to learning. So it really just depends on your interests and how you get there.
Sorry to be selfish, but I was working in marketing for years and I worked at Texas State, but this is my future apartment downtown Austin. I want to be a lobbyist for people with disabilities.
Awesome.
So this is my apartment, so welcome.
That's wonderful. And you mentioned things about evaluation, and certainly if individuals aren't sure what they want to do, or if they need some help in kind of paring down some
Right.
ideas, evaluations can take place. And certainly an evaluation could be paper and pencil. It could be a kind of a in-person evaluation, a work evaluation, depending on the individual's comfort or knowledge about the world of work.
So it's all individual, pretty much.
It has to be individualized.
Okay.
Absolutely.
That's
Absolutely. And even individuals who've had testing and maybe the testing results don't look maybe on paper the way the individual wants them to. There's a way to address that with a counselor to try to determine, success, or what does that success look like? Because again, we want to think about what are the things that we can do to help an individual achieve their goals. And they have to be realistic, of course, but we don't want to, put people in certain categories or limit opportunities where the opportunities might exist.
That's awesome. Thank you.
You're welcome. You're welcome. So, remember, there is a client assistance program if you have any questions about vocational services, and it's not a bad thing. Sometimes counselors are wary about CAP becoming involved because we do, our process is we receive a referral from an individual, the customer will contact us if they have concerns. And we evaluate the request every week, a new request. And then our supervisor, she distributes the request to each advocate. So there's about 8 or 9 advocates for the client assistance program. And each of us are assigned to work in a region. We have 2 in the Houston area because it's so populated, and then 2 in the DFW area for the same reason. But my area happens to be the South Texas and the Rio Grande Valley and El Paso County. So when we have cases that come in or inquiries, they're assigned according to the geographic area that we work. And the first thing we do is we contact an individual who has a concern, the person who wants to receive services or who is already receiving services. We talk to them directly and find out where your areas of concern to determine how we might be able to help. And then we get a release of assigned release to contact the counselor to talk with them, also to kind of put the pieces of the pie together and request records and review the records also, whether it's email, service authorizations, case notes particularly, and we determine if the concern has merit. And what that means is we determine if the concern is something that we can, if it's a violation of policy with the state VR program, or if it's a violation of federal regulation, because remember, they're federally funded, and federal law mandates the state policy that tops the state policy. So we want to make sure that they're following both, but that they're not, especially not violating any federal regulations. Again, we attempt to resolve issues at the lowest possible level. So you'll have more interaction with an advocate first than you would our attorney supervisor, although she's very involved and informed, particularly when there's a denial of services, because that mandates, it triggers a timeline in requesting a hearing. Regarding the Centers for Independent Living, we definitely have more cases with the vocational rehabilitation program due to the number of offices, the number of people in the voc rehab program versus independent living. And we take the same approach. We work with the center, the independent living counselor, and some issues that might arise might involve maybe the individual doesn't even know where their center for independent living is, and they're struggling with independence at home or access to the outside, or needing that peer support and program, self-advocacy. So we definitely introduce people to the resources in the community. And oftentimes in that case, our involvement's could be very limited because they're, that's resolved once we facilitate the introduction. But it could be more lengthy. Some other cases that we work on include, assistive technology, including vehicle modification, self-employment, and or looking at prosthetics, or individuals who might need a little bit more supports. And in part that might be based on the knowledge and the expertise of the counselor, their comfort with understanding the policy and how to navigate the policy. And I think most generally the counselors from both independent living and vocational rehabilitation genuinely want to help. They're just needing some guidance, I think. And it's very rare that we work with individuals who are kind of closed minded to working with individuals. If we run into that, we work with the managers and their supervisors to provide training and education if that were to happen.
How are you guys different from Texas Workforce Commission as far as the employment part? is that kind of the same expectations or what? I mean, it sounds like you guys are more involved, hands-on overall.
We do have smaller caseloads, and it's designed that way, but we don't have case service money to authorize services. We are there to advocate that the VR program provides services, and we inform our clients about what services are available to individuals who are looking for employment. And so a lot of us within a lot of the advocates, and including my advocate supervisor, we used to be rehab counselors with state agencies or in private practice. So we understand the process. We've worked with customers before, but our role is different now. We're advocates. And so we bring that knowledge to the table in terms of trying to resolve issues that might arise. Some examples of issues. Does that answer your question?
Yes, it does. It does. I've been on a 3-year waiting list with Texas Workforce. I'm starting to age myself out of working.
So may I ask, well, and maybe you would like my contact information, because I'm concerned if you're on a waiting list with Texas Workforce Solutions, because there isn't a wait unless it's by choice. I mean, because we've got the pandemic, and that's, if it's your choice, that's one thing. But if it's something that they're holding,
I think it's something internal that they're working out, and I've been trying to be impatient. I'm not, so I can be patient, because
yeah.
I attack everybody. So,
And if I may, I do have a general question regarding Texas Workforce, because I was a part of the program 10 years ago when they were DARS.
oh yeah.
Yeah, and they discharged me right when I was able to find a job. I only had a job for 14 months, and then back in 2015, I believe I tried to apply to Texas. I think that's when they changed it to do Texas Workforce at the time. I tried to apply, but they told me that, well, since I was already previously employed, I couldn't get back on the program. Is that still true?
No.
They changed in 2018, and I've been with them since 2017, and I keep getting older.
Yeah. So actually, the agency did merge under the umbrella of TWC, and that is because of WIOA, the change in the law that I mentioned. But anyone can apply. They shouldn't be screened out prior to completing an application, because if you've had if you're employed, you might want advancement. You might need some tools at work to help you do what you need to do. You might want a different job, and maybe
Right.
and some people might need just a little bit of help to make that transition, and that's what they're there for, is to provide help for you. So if there are delays in services due to things that don't feel right, I mean, I would use listen to your instincts,
Okay.
because if there should be a flow to the services. So if they're not calling you back, if you're being told, no, you can't apply, that is not correct.
Interesting.
Yeah.
And they told me the pandemic is keeping them from moving forward. So I just watch Netflix and wait.
Well, they are open for business. Most definitely, all the counselors are working from home. And they all have cell phones, so they can be accessible to their customers. They have access to their email. They might not be meeting with people in person, but there are services that they're providing to their customers. The range of services that I've explained to you are certainly not shut down. There are exceptions, meaning that there's internal paperwork that they need to do. Some services have been a little more challenging, such as AT services or assistive technology services that need to be done in person, or if it's better to be accomplished in person with the social distancing, that has been a little bit more difficult to navigate for just safety reasons. But in terms of job placement, vocational counseling, evaluation, all of that, all of those things are in training, all of those things are being done at this time.
Hey, Daniel, I got a quick question for you. Are you still waiting, or what the process you going through?
No, well, no, no, actually, once they told me in 2015 I couldn't apply for services anymore, actually that was actually a year before I was graduating from college. So I just went in and just completed school and did volunteer work on the side, and you know, did things with Sheila and connectability, and you know, after sports. That's really been it for the
Wow.
past 4 years.
And thank you for asking that question, Mr. Green of Mr. Acosta. And one of the things that the client assistance program can do, if an individual would like, is we would do what's called a supervised referral, which means we would help with the referral process, help with the application, you know, accompany and be a part of the team, especially if you weren't sure if you're being told the correct information, or if you've run into barriers, particularly when they said, oh, you know, you can't reapply. You know, people can apply as many times as they want to. There's no limit on applications. I've run into that. I ran into a situation where a customer was told he could apply up to 3 times and that was it, and that's not correct. So, and for some reason, you know, they put these parameters on individuals, and it's really not that restrictive.
Interesting.
Yeah, yeah. I put my name and my email and my phone in my chat box.
Okay.
I
Yeah.
work out of the San, and I can help you find, you know, with intake, you know, information, but I work out of the San Antonio office, and we typically work from home anyway. So I'm, you know, phone or email is fine for me.
Jenny, I believe Cindy has a question.
Oh, I'm sorry, Cindy.
That's okay.
Oh, you
Um,
just have a little hand up.
I worked for Low Vision Resource Center for many years, encountered many individuals who lost their job because they were blind or visually impaired, or were going blind or visual, you know, had visual impairment.
Sure.
My question is, when did CAP start advocating for people who are either lost their jobs or were getting ready to lose their jobs? When did all that start?
So the client assistance program, we've been advocates with over the VR program since 1973.
So it's up to the individual to seek your help, but if they don't know about you, then they don't ask for help.
That's right, you know, and I agree with you. I think that, well, the counselors are supposed to inform individuals about the client assistance program. You know, I just had a meeting with our regional director yesterday, and I encouraged him, you know, the staff should just be giving people a pamphlet and said, okay, here's the client assistance program. I fulfilled my duty. You know, it's really a discussion about due process, your rights, the appeals. And because a lot of times people kind of find us by accident, and we don't know about issues until people contact us, and we can talk with them about what's going on.
All the times that I received services from the Division for Blind Services, I never, ever received a pamphlet about y'all. And I didn't start hearing about you until I started inviting your organization to our Low Vision Expo, and started learning, inviting you, and you presented to our group, and I started to learn what you represent and what you do. But when I was a client for the Division for Blind Services, I never heard about you.
I'm sorry.
You know, not that I needed your services back then, but, you know, and speaking for everybody else, they should know.
They should. And a lot of times people will hear about us through presentations like this
Mhm.
and word of mouth, and we want people to know that we exist. You know, we want the counselors to remember to talk about us and encourage the counselors to have their, if there is an issue and they don't know how to resolve it, we're here to help collaborate. They're not going to get in trouble if they contact us. You know, there might be guidance that we can give or suggestions we can provide, but any HR issue that's between them and their employer, our concern is with the customer who has a disability.
Mhm.
That's who we represent. So, but please, yes, as much as you can get it. And thank you for inviting us to the Low Vision Expos. I've been to them in Houston and they certainly are fun.
Yeah.
So other examples of cases might be a communication barrier where an individual doesn't feel comfortable, or maybe they feel kind of shut down by the counselor, you know, because people are polite and they don't want to seem like they're being rude to their counselor. So it's hard for them to say, you know, to self-advocate. So we work with individuals on and facilitating that communication to ensure that the customer is receiving information that they need. An example today involved benefits counseling. I talked with a counselor who didn't know that her customer wanted benefits counseling, which is really necessary for individuals who are beneficiaries of Social Security. And that's important information to have. The counselor should have known that, but if they don't ask the right questions, or if they're perceived as being an authoritarian, it's hard to, they're not approachable. You know, I think human nature is just to kind of go the path of least resistance sometimes. And so we can help with that, with the self-advocacy. Another instance that I worked with was a vehicle modification. A very bright and motivated young lady was told that maybe she wasn't close enough to employment to look at assistance with a modified vehicle. And then she was told it was too expensive. Well, you can't deny a service based on expense. That cannot be a reason to deny anything. So we worked on making some changes, you know, getting her to a different region, and we in a different counselor, and kind of worked on building that up again so that she could get what she needed to get to work and go to school. And so that's an example of kind of a more complex instance. Another, I mentioned self-employment. An individual I worked with wanted, you know, he was a banker and he wanted to be self-employed. He was very good at it. And it took some, we had to provide the guidance to the counselor in order to kind of get the plan moving forward. But he was able to do that very successfully and get the tools that he needed in order to operate his business. And I touched base with him over Christmas and he said he was doing really well. So, you know, if you know that people have the potential and they just need the tools to kind of make that happen. And that's what VR is there for. The client assistance program, we also work on systemic issues, and some examples of systemic issues involve, I just started in 2018, and my supervisor had heard that TWC was telling individuals who have disabilities that they don't have to tell them about their voting rights. And that was something that she took a hold of and said, oh no, it's your responsibility to ensure that individuals who have disabilities know they have the right to vote. So that resulted in a change where at every meeting, every application meeting, the counselors review the the individual's right to vote, and, you know, whether or not they gave them voting information, and they have to sign off on that. So I think that was really, really important and kind of a cool thing to observe when I was just starting with the program. We were able to add policy for purchase of vehicles for individuals who need modification. There is a cap on that, but at least it's some assistance, as well as a vehicle repair policy added shortly before that. So it was vehicle repair policy was added in 2006. Vehicle purchase policy was added in 2007. That's not for everybody. It's just for people who need to use modified vehicles.
Is that a program through Texas Disability Rights of Texas, or is that through Texas Workforce?
So again, so Disability Rights Texas with the Client Assistance Program, we're advocates for the VR program. So when the VR program, when there's an issue or a violation, when they say, no, we can't help you with your vehicle repair, then people contact us. So we're advocates for the program to ensure that the customers know what their rights are, that they know what services could be provided within their policy.
We get that a lot. Connectability we're huge advocates for Disability Rights of Texas, but one of our big calls that we get is who or what organization can help me get a vehicle.
Mm-hmm.
And I know the Texas Workforce Commission will not assist in getting a vehicle. They'll assist in the modifications of a vehicle. And that's what we let people know. If you can get your vehicle and you need the modifications, as long as, I mean, like you said, there's certain stipulations, you have to be able to go back to work unless you're on the assisted living list. But for the most part, that's where we get a lot of calls in. Who can help me buy a vehicle?
Sure. So essentially, policy within vocational rehabilitation, they can assist with a down payment for a vehicle. It has to be done, it really has to be done in conjunction. I mean, people can't buy a car and get reimbursed, you know, the down payment. It really has to be done as a partnership with VR, with employment as the main goal. They can assist with monthly payments up to 6 months.
Yeah, they definitely do not let you know that.
They don't.
I don't think that any of our care coordinators are aware of that. We have 4 care coordinators that work with our members, and I don't think they know that, but they will, because I'm recording this, so they're going to watch this.
Mm-hmm. So the down payment assistance is a cap of $4,000, which can help significantly.
Now, is that for them to go back to work, or is that just for them to sustain a reasonable life?
It's, well, both, but it's for the purpose of going to work.
That's the same amount of money as a Lexus, $4,000.
Mm-hmm. When
In your dreams, Andre.
The vehicles, so it's a process, right? When people are looking at vehicles for modification, because the state has a list of vehicles that they are willing to modify because they have to meet certain crash requirements. So, so they'll evaluate that. And there is an approval, there are levels of approval that have to happen with regard to purchase of a vehicle for modification, and then the modification process itself, driver's evaluation, driver's training, and the modification. But it can be done. You know, it's not an easy, fast process. It's not a slam dunk. It's not, you know, in everyone's, you know, immediate goal. But it's something that the individual can definitely have a discussion with their counselor about if it's, you know, if it's warranted, if it's needed.
I have a question.
Yes.
The payment assistance is at the beginning of when they start making the payments on the van, or is that when they're defaulting on payments?
No, it would be at the very beginning.
Okay.
That's a good question, though.
Thanks.
Mhm. I had one individual I was working with she was contacting different, dealerships to see what they would have available for, if they knew of any programs for vehicle donations. It is hard to find a vehicle if you can't, if you are on a fixed income or just don't have that additional resources, it can be very much a challenge. So when we work on systemic issues or work on issues, of course, I mentioned we work on it at the lowest possible level. So that would be between the advocate, the customer, and the counselor. And if the counselor says no, we go to the supervisor. If they say no, we go up to the manager. If the manager says no, we'll go to regional and then to state office. So we do have to go up the chain of command, just like with most every organization, in order to see if we can resolve it at our level.
Well, if there are no other questions, I want to be very mindful of y'all's time because we appreciate all of your time. Are there any further questions?
I just need an email address for Janine.
I believe she put it, oh, well, Cindy and I can send it to you. Oh, yeah. Do you want to just write it down?
Sure, that's fine.
Okay.
I'll give it to you. Are you ready?
Mm-hmm.
It's JHAN as in Nancy, Z as in zebra, A as in apple, L at drtx.org.
Thank you.
You're welcome. I hope you reach out to me with any questions that you have.
Yes, ma'am.
All right. Well, if there are no other questions, I think, Priscilla, you're the only one that I really am not familiar with. If you would like more information or the contact information, you can send me an email. Let me put my email in the chat.
And Sheila, you said you're recording this, correct?
Yes.
Okay.
What a pretty cat.